AM 650 presents You and the Law, a comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Hello and welcome to You and the Law here on AM 650. Today we're focusing on the category of wills and estates, and we are delighted to have David Hobbs and Ian Giroday back from Hobbs Giroday in Vancouver. Gentlemen, welcome back to You and the Law. Great to see you both again.
Good to see you, Sterling.
David, Hobbs, remind us a little bit about yourself, the Hobbs of the Hobbs-Giroday combination. Tell us a little bit about yourself and your firm, please.
Well, I graduated from UBC, Sterling, and have been practicing for about 30 years. And I started out traditionally with a large law firm. I was a partner there for many years, and then I started my own law firm. And Ian and I now practice as Hobbs Giroday. We're across from the courthouse on Howe Street, and have been doing that for the last 6 or 7 years.
And Ian Giroday, you also came into the large firm approach out of law school, and then eventually find your way to a partnership with David.
Right, the same law firm, and that's...
oh, is that right?
Yeah, that's sort of what drove me getting back together with David, initially about 13 years ago now, and then into our partnership in 2005. So, yeah, sort of I'm about 25 years at the job, though. David's a little...
Got a month or two more on you?
He's been at it a little longer than me.
Now, both of you, Hobbs Giroday is all about wills and estates and wills variation. Have you both been wills and estates lawyers since the get-go, or did you start out in other areas and then gravitate towards wills and estates, David?
I'd say the latter. We practice most areas of litigation, but over the last 5 to 10 years, the estate litigation area has become very prominent due to the demographics and aging baby boomers and so on. And that's an area of practice that we specialize in now. A lot of our practice is estate litigation.
Now, Ian, the magic word there was litigation.
Right.
You guys are fighters. You guys spend a lot of time in court on behalf of clients who are disputing wills, correct?
Right. And David used the term estate litigation rather than wills and estates, and I want to emphasize that because, the listeners might perk up and think, Hobbs Giroday drafts wills and does estate planning. We don't.
Right, okay.
We deal with the disputes around wills or the lack thereof or issues around the administration of estates.
Okay, so what happens when wills don't work out? That's when the pros at Hobbs Giroday take over and quite likely end up in court. David, let's talk about wills first, though, because now we know that, as Ian has just mentioned, Hobbs Giroday doesn't do wills and the drafting of wills. You deal with the aftermath of wills. What percentage? We talked about this on the last show with a rather disturbing headline that I had come across, courtesy of our friends at the Cancer Society, that a significant percentage of British Columbians, almost 45% of British Columbians, don't have wills. Is this typically across Canada? Does almost half the population not have a will on any given day?
Well, I think that's correct. I think a large percentage of the population doesn't have a will. Everyone should have a will because you're just leaving your administration of your estate, your last wishes as to how you would like your affairs handled. You're leaving it really to the government and to the legislation that relates to intestacy, which is the technical word for people who die and don't have a will. They die intestate. And then you have to look at the legislation that deals with intestacy, and it gives you the rules as to how that person's estate is going to be distributed.
Ian, you've been at this a long time. Why have you found, doing your homework and working on so many of these cases, especially in court, why do you think so many people don't have a will?
Well, I think there's a variety of reasons. Lethargy is one reason, just not getting around to it. I think as well, there's younger people don't think about it necessarily when they don't have much by way of an estate.
I suppose
when they're not
right.
married, when they don't have children.
And that might skew the numbers a bit, too. It's hard to imagine a 23-year-old single person just starting out on a career path necessarily thinking even about a will, right?
Sure. I mean, I can be my own bad example. I'm pretty sure that my first will probably wasn't done until I was, in my early 30s, perhaps.
Well, me too.
Yeah.
And kids. That's what did it for me.
Yeah.
Once the kids are starting to arrive, you realize, oh my gosh, time to get things organized. David, a will is all about distribution of one's estate, right? It's a roadmap for how the person with all the dough wants this money to go, correct?
That's correct. It's a recipe, it's a roadmap, it's a set of instructions, and it takes effect when you die. Until then, it doesn't take effect. It can be changed right up to the few minutes before you die. And but your will, when you die, tells your executor, who's going to receive all of your assets and your liabilities and administer the unwinding of all those things.
Right.
It gives them the instructions, and it revokes your prior will. It appoints your executor, and then it sets out that all your bills are to be paid, your creditors, and then it provides for the distribution of the net value of the estate.
If there's a balance, a positive balance, then that money gets distributed, again, according to the outline provided by the person who wrote the darn will.
That's right. I mean, the taxman gets paid, the creditors get paid, and if there's a balance left, which in wills we refer to as the residue, then it gets distributed according to the terms of the will. There can be specific gifts, there can be general gifts, and there can be insolvent estates where the liabilities are greater than the assets, and in that instance, then the creditors are dealt with like a bankruptcy almost. They get a percentage of the estate, and there may be priorities and so on. But
so if you were in line for an inheritance from that particular estate that turned out to be bankrupt, you may never see a dime once the creditors are all pieced off.
Yeah, we get lots of clients who come in and they're interested in their gift from an estate, and they rudely and unfortunately discover that the deceased wasn't that transparent about their dealings, and they have mortgages and didn't pay their taxes.
Sure.
And all sorts of bad surprises come up in the financial analysis, and the estate ends up being insolvent.
Ian, there's kind of a myth out there, help me with this one, whereas where the tax man is basically waiting in the wings with a knife and fork, and the second you die, they're going to get pieced off first, and there's a death tax and an inheritance tax and a tax on a tax. What's the tax story with wills and a person's death?
Right. So you have to do your usual income tax return for the year of death.
Right.
If there's assets that continue to accumulate income even in years after death, there's income tax returns to file. But there's no death tax or inheritance tax per se. In fact, the only portion of an estate that might be considered a tax is really the probate fee, which is what you pay to the court registry,
Okay.
which is a fairly modest percentage of the gross value of the estate. Now, there are tax issues. For example, properties other than the principal residence will be deemed to have, there's a deemed disposition on the date of death.
Okay. Like a cottage or an investment property of some kind?
Right. So that will dictate, I might be a little off on that. But there are deemed dispositions of various assets.
Okay.
And certainly when the property is sold that is not a principal residence, there will be capital gains on that.
Okay.
From
As there would be with anyone.
right,
Then,
from cost base to date of sale or date of death at a minimum.
David, what's the primary reason people come to Hobbs Giroday? They're upset, obviously. There's been a will. They have found out through any number of possible sources that their expectations regarding what they thought they were in line for simply haven't panned out. In fact, they may have thought they were a principal recipient and ended up not even being named. So is it anger? Is that the primary reason people head down to Hobbs Giroday downtown?
Well, the emotions behind it are very, very deep, but I always think about the family sitting down at the table for dinner, and you sit down at your chair and you look at your plate, and everyone else has got food on their plate and you don't.
Mm-hmm.
And you're kind of wondering why. And that these sorts of surprises are very upsetting to people, and a lot of times things have happened between other people or advisors that come as a surprise upon the death of a close relative, a parent, and you discover that your expectation is not going to be fulfilled, or at least fulfilled easily, and that makes you angry, it makes you upset, it makes you despondent, and people are very, very, very upset when they come in and start discussing the disappointment that they have over the circumstances that they're looking at.
Well, I guess, Ian, in some cases, people roll a fair bit of emotion into the drafting of a will. So it's not too surprising that at the other end, at the receiving end of all of that, it wouldn't produce probably an equal or even greater amount of emotion, right?
That's very true. We see wills where there are decisions or gifting decisions made based on a worldview or a view of your family that really isn't necessarily isn't valid and not based in reality. There might be decisions based on old cultural ideas about,
yeah.
For example, everything should go to the eldest son because that's the way it's always been,
Yep.
or I'm not leaving anything to my middle daughter because she never visited me, when in fact that might not even be true.
Right.
So there's lots of that. So we certainly have a lot of people coming into the office who don't think that they've been treated fairly, and sometimes it's not just they're surprised by the outcome. Sometimes they know that they're going to see a will where they're not going to be treated fairly.
Oh, so they were expecting this all along.
Well, it might be someone who has really not participated in their parents' life.
Right.
Perhaps were through an early divorce, was essentially estranged from the parent they didn't live with for decades.
Mm-hmm.
But nonetheless, they may come to us and feel like they have there's been an obligation that they didn't see in their lifetime that they want to try and correct.
How long, David, when someone requests an interview with you or Ian or one of your team down there at Hobbs Giroday, how long does it take you to assess a situation? Someone comes into your office and they're good and worked up. They've been left out of a will. They thought they were in line, etc., etc. You know the story. How long does it take you to figure out that this individual may have a legal leg to stand on and this person's been really ripped off, or this person's trying to dance me? How long does it take all that to settle for you?
Well, I would say quite often you can get a sniff, if you will, or a smell that there is a legal issue or a problem from a meeting,
right?
Or maybe a meeting and looking at some documents, and so you can get a preliminary view that there's something worth looking at more deeply. Once you get beyond that, then you're usually making the decision whether you're not going to pursue more information, you're going to investigate more.
Right.
You may start a lawsuit, which in effect is a platform for further investigation and gathering information. So I would say it's sort of a two-stage process. You decide whether or not there's something worth pursuing or not, what it is, and then you set out a series of steps to get more information about that. That information gathering process might take months.
Sure.
Yeah.
Well, and Ian, so in order to be prepared for that first meeting that David's now talking about, what sort of helpful paperwork is it useful to bring along with you when you have that first meeting with the lawyer to decide, have I been ripped off here? Have I been left out of a situation where I definitely feel entitled? What sort of paperwork is helpful for that first meeting? As David says, it could go on the paper chase for months, but first time out.
Sure. So certainly the will is an important document we like to see at the outset. We often ask people to write a bit of a chronology, to give us a little bit of their story, so that we can understand the family dynamic a bit and what it is that's bothering them, what the issue is or issues that can be gleaned from that story.
Okay.
Sometimes we're looking at issues about what's in the estate and what somehow is not in the estate.
Mm-hmm.
Are there joint bank accounts, or is there property in joint tenancy and so forth, real property, land, so that we can get a sense of what size of an estate we're dealing with as
mm-hmm.
well.
So being organized, David, is hugely beneficial to legal professionals like you and Ian.
Yeah, understanding all the facts, but the difficulty for people that come in is we know what facts are relevant.
Right.
They don't, but
Yeah.
they know the facts. They just don't know what to tell you.
Sure.
And I think of a story of a missing will, and people eventually explaining to us that the deceased always kept the will in a tin box over the fireplace. But they wouldn't know to tell you that when they come in. They just say the will's missing.
Right.
But it's really all these interesting circumstances surrounding the story that start to color and paint the picture of what's going on or what might be going on. The devil's in the detail.
Sure, of course.
And so you try to engage people to help them tell you the background and the detail and the story, and to paint the picture so that you can start to get a feel for who the actors are, what may have happened, and so on. It's a fleshing out, if you will.
So what happened to the will that was in the tin box over the fireplace? It was always there for all those years, and suddenly it's not there anymore. What happened?
Well, in that particular case, it's interesting that the deceased always told the family members everything about the estate plan, where the will was, what it said, and so on, and never ever suggested that there was any other will.
Right.
So it's a mystery as to what happened to that will, and
Oh,
one of the actors must know something about it, but that's a story to be told in the future, I suppose.
It remains undiscovered at this point. Interesting stuff. You and the Law here on AM 650. Our guests are Ian Giroday and David Hobbs from Hobbs Giroday in Vancouver, and we'll be right back.
This is You and the Law. There's more of the show still ahead on AM 650.